initial court, the circuit court, and get a new ruling, but the judge there still said the statute was similar enough that she was lifting our gag order, and the FBI or the Justice Department informed our attorneys they would no longer oppose us in court, although they did try to convince the court to just drop the whole thing. But the court said nothing doing. They would allow the ruling to go ahead. So we had a judge declare our gag unconstitutional, and after that we were free to talk.
Nick Merrill, you too did not know who these librarians were, right? You knew them like you were known as John Doe.
Correct.
So what was it like going into court? You couldn't be identified.
Correct.
No one knew you were the person who was bringing this precedent-setting case.
Right. Like the librarians, I really wasn't able to go to court most of the time. There was one or two occasions in which I did go where they knew beforehand that there would be a huge crowd there. When I went to the Second Circuit, there were entire law school classes there, so there was just dozens of people, and it was standing room only. But I had been instructed that I couldn't talk to anyone. I shouldn't even say hello to anyone. I should just kind of keep my head down and listen if I like to, but just, you know, be really quiet because, you know, I was in danger of violating the gag. So.
George Christian, you watched the case from the Hartford courthouse when it was taking place in Bridgeport by closed-circuit TV because you were considered a national security threat, you and the three other Connecticut librarians, like, what, Peter Pace, head of the Plainfield Library?
Yes, Peter Chase.
Peter Chase, sorry.
We were considered, the release of our identity would be considered a national security threat because they reasoned then whoever they were interested in would realize that the FBI was closing in, although with 26 libraries, I doubt they could really make that a case. We did get to attend the appellate court along with Nick Merrill. We didn't know at that time whether Nick was a male or a female. We were instructed to enter the courtroom in New York independently, to enter the building independently, not to sit with each other, not to have eye contact, not to have eye contact with our attorneys. But at least we could participate in the audience and watch our case being argued.
Now,
the ironic...
Yes, go ahead, George.
The ironic thing about our case is that the FBI so poorly redacted all the documentation in the court that the press was able, looking at the court papers, to uncover Peter Chase's identity and my identity very early, within 2 weeks of the initial case. So there were countless news stories that identified us and identified Library Connection. And at the appellate hearing, our attorneys had a sheaf of newspapers, clippings, in which our names are mentioned, and they said that the gag order is just ridiculous at this point. And at the same time, the defense attorney for the government got up and moved to strike this evidence, which consisted of previously published newspaper articles from the record. It was just totally bizarre.
Nick Merrill, can you talk about why you dealt with this for 6 years, why you were willing to go through this, the importance of speaking out?
I believe it's so important that people have the right to freedom of speech. You know, it's also a constitutional matter. I mean, I grew up learning about our system of checks and balances, our Bill of Rights, and essentially, you know, it's a total cliche, but, you know, all that's necessary for evil to triumph is for good men to do nothing. I felt this was something I had to do. And as an internet provider or a systems administrator or a telephone technician, you have a lot of information that paints a really vivid picture about people's personal, private lives and communications, and I believe that comes with a great degree of responsibility, that you're essentially a steward of people's personal and private matters, papers. So it seemed to me it was a moral obligation I had to protect the privacy of my clients.
You want to start a nonprofit now that would help people deal with this? How many national security letters have been given out?
have been given out in total. I don't know if anyone knows the answer to that. What we do know comes from an internal investigation of the Department of Justice from their Inspector General, and I believe that the number is like 192,500 between the years 2003 and 2006. So it's roughly 50,000 a year.
And Vermont Senator Patrick Leahy has demanded information on what's happening now. What is the status of these national security letters?
Yeah. I believe the Department of Justice is now voluntarily giving information to Congress about it, but there's nothing that really there's nothing that really compels them to do so.
You settled for how much with the government?
It wasn't that kind of a settlement. It was merely a mutual agreement that, we would drop the current appeal and they would let me partially out of the gag. I mean, there was no financial aspect to it.
And George Christian, why did you and the three other librarians, Peter Chase of the Plainfield Libraries, Janet Nochek, the Portland Public Library Director, and the Glastonbury Public Library Director, Barbara Bailey, why did you risk so much, gagged for so long, not being able to tell your colleagues what was happening? Why do you think this is so important?
We think that libraries are one of the cornerstones of a democratic society. People ought to be free to go to a library and get information that the librarians have provided. Librarians try to be impartial, but just provide quality information. And really, you ought to be able to go to a library and check anything you want, whether it's political, whether it's research into breast cancer or whatever, without the FBI looking over your shoulder or anyone in the community looking over your shoulder. And that's a long tradition that librarians have had. It's part of the Library Bill of Rights, first issued in the 1940s. But more importantly, we all take the constitutional protections that we have for granted. And the truth is, these protections are only there as long as we're willing to demand, that we, the public, are willing to demand that they be enforced. It's always tempting for those in power to encroach upon these civil liberties in the name of expediency. And if someone doesn't stand up and say, hey, wait a minute, before you know it, your liberties will be gone. We have a history in this country of reacting to any external threat by throwing the baby out with the bathwater and clamping down on our civil liberties.
Well, I want to thank you both for being with us. George Christian, Executive Director of Library Connection Consortium of the Internet System of the Libraries around Hartford and Connecticut, and Nick Merrill, President of the Internet Service Provider KLEX, who filed the first court challenge to the FBI's national security letters in 2004. This from the Washington Post. As we move on to the primaries around the country, the Obama administration seeking to make it easier for the FBI to compel companies to turn over records of an individual's Internet activity without a court order if agents deem the information relevant to a terrorism or intelligence investigation. The administration wants to add just 4 words: electronic communication transactional records, to a list of items that the law says the FBI may demand without a judge's approval.